Welcome to Cross-Border Tax Talks, where we discuss the latest trends in international taxation, from EU updates to the OECD's latest developments. I'm Doug McHoney, PwC's International Tax Services Global Leader. The Pillar Two engine from PwC is a game changer for Pillar Two modeling, provision, and compliance calculations. Built on a graph system utilizing over 20 years of international tax technology, this centralized rules engine is built by a team of Pillar Two tax experts from around the globe. PwC's Pillar Two engine is currently available as a service and will be licensable in July 2024. On this week's episode of Cross-Border Tax Talks, we're at PwC's Global Tax Symposium, Europe 2023, in Rome, Italy, where I'm thrilled to have Will Morris back on the podcast. Will is PwC's Global Tax Policy Leader and a frequent guest on the Cross-Border Tax Talks podcast. Will, welcome back.
Thank you. For reasons I can't understand, Doug. Thank you anyway.
Well, there is no ending of global tax policy things to talk about. The last time you were on, we talked about FSR, the Foreign Subsidies Regulation, that we are now in the throes of. It is implemented and going. We are not going to be covering that today, but I do want to talk a little bit about Pillar Two, and then also wanted to spend a little time at the end talking about an article that you recently published in Bloomberg Tax on tax and ESG reporting. But maybe before we dive into some of the substantive material, you've been a key part of PwC's U.S. Policy on Demand news platform over the last 5 years. You and I have had a chance to do a number of pieces on that. But you've recently joined me, Will, in the YouTube game with the launching of Global Tax Talks, including Tax in 60 Seconds with Will Morris. Will, tell us a little bit about that and where listeners can find your content.
Right. Well, so it's partly a sort of homage to Policy on Demand because it's been so successful in the US. But when I took over this new role, I wanted to take that global. And you know, there are a number of things about it. It's about how do we get information to clients in ways that, you know, suits them, doesn't suit us. We're wedded still, probably a little too much, to the 20-page memo and the 30-page slide deck. But actually, most people don't have that time. And what they want is, I mean, as you've done with your podcast brilliantly, what they want is the news they can use, essentially. And, you know, doing it on... There's a benefit, obviously, to doing it on a rhythm basis, you know, once a week, whatever. The 60 seconds speaks to, you know, the TikTok generation, essentially. I mean, it is how can we get, you know, the key things we need in 60-ish seconds.
60-ish. I was going to note that I think I've listened to all of them. I'm not sure any of them have come in below 60 seconds.
No, but none has been longer than 120.
None has been longer than 2 minutes. Right. So it's definitely worth the investment. I think they're very, very well done. Right. And I will also note that when I started this podcast, I committed to have all of them under 30 minutes. And I'm not sure, this is episode 141. And I think I maybe have one episode that I got below 30. So
there's a plus or minus.
There's a plus or minus. But so I would encourage listeners to check you out. You can find it on YouTube, follow you on LinkedIn. You post it regularly, but some really good and enjoyable content. And I agree that I think, you know, I spent a lot of time, Will, writing articles that nobody read, except for other advisors, and particularly not taxpayers or clients, and really have had the opportunity to connect with the international tax audience through the podcast, and I've gotten a lot of favorable feedback. I appreciate the kind words, but I do think finding alternative ways to reach our audience and share information, particularly some of this technical stuff, is really important. So I commend what you're doing.
Thank you.
So, all right. So let's get into some of the global policy stuff, and particularly wanted to hear your thoughts on Pillar Two. So have had a lot of guests on over the course of the year. We're recording this towards the end of the calendar year in 2023. I think that the OECD had officially said in November, and we'll talk a little bit more about this during an OECD conference in the US, that the official count is 36 countries will be adopting Pillar Two in 2024 of the 140 or so, whatever, that committed to it. But what are your views, Will, just in general? How is the Pillar Two process going in general? What should listeners be mindful of? Kind of where are we?
Well, look, I think the crucial thing to remember is, and you know, despite what I'll say in a second, is Pillar Two is happening. I mean, it really is happening. And you know, the countries that are doing this, of the 40 odd, you know, 27 are in the EU, or actually, I mean, we have to moderate that number because some have opted out, but the EU is doing it. Other major countries are doing it, the UK, Canada, etc. So, I think that the people should not imagine that, somehow this is, it's still going to go away. It's not going to go away. This is going to happen. And, what will definitely happen are IIRs next year. More interesting question is what happens to the UTPR in 2025. And, as you've noted, whatever it was, 45, 46, 48, whatever that number was.
36, I think, in 2024.
right.
But then I think that of the countries that have specifically said they're going to do in 2025, that's where you get to the 56
Right.
or something number. These are not
That's
exact
right. So,
numbers.
there are still a number of countries. There are a number of countries which have committed to what is essentially the OECD timeline, particularly the EU, obviously, because they put that in the directive, but others as well. Some others are clearly waiting until 2025 to do both parts of this. The UTPR, as we've discussed before, has been the subject now of political concern in the US for 6-9 months, and we've seen in particular the Ways and Means Committee members, Republican Ways and Means Committee members, talking about this. So I think we can still expect to see some change in aspects of the UTPR, and we can get into the details of that later. But the main thing is it's happening. Okay, now let's talk about how is it happening. And countries are obviously legislating this within the EU. They have to follow pretty closely within the tram lines of the directive. In other countries, we're seeing some different language use, some different changes. And one of the issues, the concerns, I guess, that I've always had about Pillar Two is it's meant to be a common set of rules. But absent a world tax government, in various countries, firstly, governments will enact it in slightly different ways, but much more importantly, what happens when it gets into the hands of the courts? There are precedents, whether it's civil law in a different way, obviously, but there are different ways that courts can look at this when the administrators get hold of it. Then sort of how do you deal with those cross-border clashes in interpretation when there's no overarching treaty which does all of this? So I think we're beginning to see some of those concerns being raised. Now, the OECD has some proposals around that. Will they work? Well, we don't know because they're still in the relatively early stages. So Pillar Two moves forward, but as you said, we are currently in November of 2023. On January 1, this comes into effect. The IR comes into effect in many countries. Do we have not just the legislation but the guidance? Do we have, we'll also talk about what the status of the OECD commentary is on this. But, do we have if we look at the US, for example, you have legislation, you have regulation, you have implementing regulations. What about forms? I mean, we know that forms are being produced, but a number of countries have said, well, we'll take the Globe Information Return, but we're also going to need our own return.
Particularly for QDMTTs.
Absolutely. These are big issues. And I did hear one senior tax official say in the recent past, well, this actually isn't really a problem because, the tax authorities aren't going to need to get this stuff until the middle of 2025. To which the answer was, but businesses are going to need to be doing this from January the 1st, 2024.
Particularly for those public companies
Absolutely.
that are going to have to disclose in their financial statements.
Yeah, no, absolutely. So there's a disconnect here. So, we have, in many cases, the basic infrastructure now, but I'm not sure that we have, let me use an architectural analogy. The frame of the building is up. I'm not sure we have the floors, far less the doors and the windows in some cases. So, how exactly is this going to work? And we've had discussions about, could there be soft landings, a soft implementation first year? Not clear.
Yeah.
Not clear at all.
Doesn't feel like that.
It does not feel like that. And therefore, when the rubber hits the road, I think so I'm going to torture this analogy to death. When the rubber hits the road, there could be some bad skids, or there could even be some crashes in some cases.
You are mixing some metaphors
I
between
really
the
am.
architecture
No, absolutely.
and
You've invited me on before, you know that.
So I want to double click on a couple of those. Sure. The first one is particularly related to how are taxing authorities and just jurisdictions and courts, for example, going to interpret this. One of the things that the OECD recently had come out publicly and said that they may issue, instead of some administrative guidance, some FAQs, some frequently asked questions.
Yep.
And which caused just a whole host of questions in my mind. Is like, well, so does that mean that's just supposed to be like interpretive guidance for the administrative guidance? But obviously the OECD is not a legislative body, so how do those FAQs get incorporated into domestic legislation? And obviously from a U.S. perspective, that wouldn't be the case unless they came in through some sort of regulatory, of course the U.S. is not going to be implementing Pillar Two, at least in the short term, but I just understand U.S. law. How does that type of guidance get incorporated into domestic legislation for those implementing jurisdictions? The other thing that you had mentioned, and I want to maybe spend just a little bit of time on the UTPR, because I think that we had Pascal was on my podcast almost 9 months or so ago and reminded me that the Pillar Two income inclusion rule was really designed after GILTI.
Yep.
And so we have kind of the GILTI, or we have the Pillar Two income inclusion rule that'll be effective in 2024. And I think many of us can kind of get our heads around that. Well, it's a parent company that's collecting the top-up tax from the subsidiary, whether it's the UP, the ultimate parent entity that implements, or an intermediate parent entity. It's like a CFC rule. Yeah. Like, we can get our heads around that. But in 2025, when the UTPR kicks in and all of a sudden subsidiaries can collect the top-up tax from brother-sister companies, or potentially collect the top-up tax from their parent. Now, we know that the U.S. was able to successfully get the OECD to agree to effectively exempt the U.S. from the collecting of the UTPR top-up tax from a U.S. parent by its subs. But there are other jurisdictions where that will not necessarily apply. 2025 really seems like a time of reckoning, because now any implementing jurisdiction, if you're a U.S. parent or let's say a Chinese parent or some other jurisdiction that has not implemented Pillar Two, all of a sudden, if you operate in one country that has implemented the UTPR, all of a sudden your entire structure, all of the jurisdictions are at play. And we won't have, presumably not going to have some sort of treaty. How does this get adjudicated? I mean, like 2024 is challenging for taxpayers to get the data, but 2025 really to me seems like the time of reckoning of like, how is this all going to work?
Right. Okay, so there are two big questions there. So let's come back to the UTPR. But this question about FAQs is really interesting because, one of the sort of the OECD has no legislative power. It can approve things. So, things go through an OECD process. They're an OECD-approved document. It's an intergovernmental agreement, but it doesn't have the force of a treaty. So, one of the ways that the OECD has done all of this stuff is by essentially getting G20 buy-in. But again, that doesn't give it legal standing. So, when the model rules came out, countries committed themselves to implementing the model rules in pretty much the language that the model rules are in. It's always been less clear, putting aside the question of FAQs for a second, it's always been less clear to me what the status of the administrative guidance is. And I was just looking back through the EU directive, but I think the UK says pretty much the same, which is this is really helpful interpretive guidance. What it does not say is this is binding or precedential or anything like that. So again, come back to my point about what the courts do when they eventually get their hands on this. Who knows? Now, obviously, some countries are actually implementing, the guidance. They're just incorporating it into their legislation.
Right.
They're at liberty to do that. The EU directive says they can do that.
That's a recent announcement from the European Commission.
Well, that's a different one.
Okay.
So, there is something actually in the directive which says, this may be useful. You can incorporate it if you want to. Let's come back to that other one in a second, because that's also
that's another point.
That's quite interesting. But they don't have to. I think again, this is not a metaphor. Actually is an analogy this time with the transfer pricing guidelines. There are some countries which, incorporate the transfer pricing guidelines into law. There are some countries which say whenever the transfer pricing guidelines change as a result of an OECD agreement, then our law will change as well. It is not clear to me with the guidance, firstly, how many countries have actually incorporated it into their law, and second, whether any of them have done any of the quote-unquote ambulatory stuff, which would allow, as changes come along, because they're going to continue to come along, what they'll do. So then you get onto the FAQs. This is Brave New World stuff. Everything in this project is new. So what's the status of the FAQs? Well, it can't be any greater than the administrative guidance, And my guess would be, if you're looking at this logically, it has to be less. So it's helpful. It may be illustrative. Who knows how some courts are going to take it? Courts have looked at OECD stuff very strangely sometimes. I mean, despite the fact that it has no true international legal standing, they have taken it as soft law, essentially. So it's possible, again, that makes some difference. But I think at best, it will be helpful, hopefully, and articulate some points. But, if it goes against a taxpayer, if for that matter a government feels it goes against them, I don't think it has any sort of binding status at all.
And then any reaction to the comment on the day of reckoning in 2025?
Oh, no. Well, I
UTPR?
was just allowing a pregnant pause for the UTPR. Look, I mean, it will be fascinating to see how the UTPR turns out, because it was always understood that there needed to be some mechanism to back up the IAR in case there were just countries which weren't in it in particular, including parent jurisdictions. You don't want to allow open season for a tax haven that you don't like, investment hub, that you don't like to do that. But at the same time, because of this really massive, unannounced, I think largely undiscussed change which took place in December of 21 when it moved from, the undertax payment rule to the undertax profit rule, or whatever, that opened up this issue of, in particular, the parent jurisdiction, which was simply, I don't think, understood by almost anybody. I mean, we'd known for a long time, because the UK had told us in public that, yes, this was aimed at the US to a certain extent. It was the undertax payment rule. It was aimed at FDII in particular. But I think nobody imagined in their wildest dreams that it would apply to the R&D credit, for example,
right.
Or indeed to pretty much any other credit, low-income housing tax credits, any of those types of things.
Any of the to your point, the non-refundable
that's right, yes.
tax credits.
Or put slightly differently, one which didn't cause a deduction in a foreign country and an inclusion in the US.
Right.
So that was just a big change, and I still don't think that people have fully digested that. A year and a half ago, I was talking to people about, do you understand that this could have an impact on credits? Well, we don't know what you're talking about. Well, okay, here we are. You raised what was previously thought of as the South Korea issue, which is, they come in a year early now. It looks very likely that they'll move back to 2025. Which, could they impose the UTPR on the rest of the world? I think there are two elements to that. The first is that realistically, that's as much a political question, if not more a political question, than it is a technical question. Technically, they could try. It's kind of extraterritorial, as we've discussed before. There are elements of the UTPR where you are clearly taxing another country's income.
Sure.
This is outside the treaty network. Outside the common understanding of the treaty network.
Particularly the ability to be able to tax a sister company that you've got no ownership with.
So there's that issue. I think that's partly a political issue. I also continue to think it's a real practical issue, because particularly with, you mentioned other parent jurisdictions which may not adopt the globe rules as well. We can talk about ones which do in a second, but the ones which haven't, how do people get that information? How do you force that information? This is an issue we looked at, first, almost 10 years ago now, in relation to the OECD country-by-country reporting. Could you force a sub to file even that relatively basic information in the place of its parent? The answer is no, because they have no legal right to the information. If you look, and you mentioned the, I will say, amazing Pillar Two engine at the beginning of this, if you look at the amount of information which you need to feed into that thing to get accurate calculations, it is staggering.
Yes,
and
it is.
If somebody doesn't give you that information, you are not going to be able to make it up. And if you make it up, you, in a sense, only make the legal issues, even worse. Because then you're doing a guesstimate of what somebody else's income is in another country before you tax it, it having not arisen in your country in the first place. So I think, again, all of that becomes quite tricky. So I would expect to see more action on the UTPR. There clearly needs to be something like a UTPR, as I said, to prevent some countries setting themselves up as right. UPE jurisdictions. But I think that bits of it are going to need to change. So, I think there's still more of a conversation to be had there. And part of the issue is that, at least I get the impression from talking to governments that they're just tired at this point. And they know they have a lot to do. And what they, at the moment, really don't want to contemplate is, some major-ish change to the UTPR as well. I mean, not that they've legislated the UTPR, and many countries haven't.
Yeah, they've kicked the can.
Yeah, they've kicked the can down the road, including some quite large ones.
Yes.
But they don't want to think about this now. They have plenty of sort of current issues on the plate. Also, I think it has to be said, and I am going to say this, that the UTPR, the US, not the UTPR, the US, United States, is not the most favoured jurisdiction at the OECD at the moment, and therefore, further accommodations towards the US can be quite hard to win. So I think that we are going to need to get closer to the beginning of 2025, maybe even this time next year, when there is a serious discussion about, okay, what do we need to do here?
Mm-hmm. So I want to come back to that
Sure.
U.S. point, because we'll sort of tease that out, particularly with the R&D, and you've mentioned that a couple times. But the European Commission put out an announcement in mid-November regarding subsequent administrative guidance that came in after the EU directive. And there were questioned whether substantive changes kind of post the EU directive, and one of that comes to mind is the market transferable tax credits that came in. So what did that guidance say? And there wasn't a lot to it. So, but what did that guidance say? And then really the follow up is, what does that mean?
What did it say? Oh, it said this is okay.
So the later administrative guidance, even if it's substantively different, is okay.
Yep. I mean, it was pretty basic,
Mm-hmm.
and there wasn't a great deal of further explanation or argumentation around that. It's an interesting question because obviously when Europe was when it first put out the draft directive, and then when eventually it was adopted almost 12 months later, they always had in mind that there was going to be this subsequent guidance, and there are references both particularly in the recitals to the directive, but also to a certain extent, in the operative sections of the directive, which say, this is useful, this is helpful. This type of guidance. Countries can incorporate it if they want to. But what they do, this is again not completely on point. It sort of is on point because, in a sense, was the transferable credit decision essentially just a reinterpretation, or was it more of a safe harbor, or what exactly was it? And again, there is a provision in the directive, and we'll probably come back to this in a second, which, again says, yes, if there is essentially, an internationally agreed safe harbor, then that's going to be okay for the purpose of the directive. But also it says this has to be consistent with the directive as well. So, again, how far can you push that? And as you know, I mean, I guess at some point somebody could take them to court if they wanted to on that. Yes, well, I'll be retired by the time that decision comes out. So,
I mean, at the risk of being provocative, they were very defined, if we look at the model rules and commentary, on a refundable tax credit. And to bring in a market transferable tax credit feels like a more substantive than interpretive change. But I certainly think that is arguable.
Well, I'm just a humble country attorney, but I'm in two minds about this because, as I said, a year and a half ago, I was talking to people about, are we sure that we really, want to crash all these credits, essentially? To which I don't think the answer is yes. I totally take the point that there are, credits, again, can be engineered in such a way that, they give benefits which are either worthless, which is an argument which a number of the OECD and the IMF and others have made about some credits in developing countries. But there are some credits which are needed to deal with market failure, or because actually that's just the way the government has chosen to incentivize those things. So, on the one hand, I don't disagree with the result. On the other hand, the country lawyer in me, looks at refundable and thinks, well, that doesn't mean transferable.
Right.
And, again, I'm not going to be the interpreter of these, but somebody will interpret them.
Yeah, I think the most important thing, Will, for listeners is, particularly with the EU, but this could be other jurisdictions as well, about whether countries who are enacting in 2024 will be able to include, and that was from the July administrative guidance that this concept of market transferable tax credits came in. Will they be able to bring that into their domestic legislation, just given the way their domestic legislation works and the administrative guidance and this this new clarification of the EU directive didn't come out till November. Well, for example, France and Sweden are very far along the way and hadn't included that. Are they actually going to be able to include that? Can they bring in retroactive changes under their, domestic constitutional rules, for example? And so I think it's important for listeners and policymakers to understand that, if you're a parent company in one of those jurisdictions and you're operating in the U.S. and plan to take advantage of these green energy credits in the Inflation Reduction Act, it is possible that if in 2024 those rules are not enacted by that ultimate parent entity, that they will be collecting the top-up tax for those Inflation Reduction Act green energy credits if they can't get the MTTCs in, the market transferable tax credits. And Treasury and the House Republicans had lobbied to the OECD. They kind of fixed the issue, so to speak, for U.S. parented groups, but may not have fixed that for non-U.S. parented groups operating in the U.S. And then the kind of related issue that you had hinted at earlier is the R&D credits. Obviously, the U.S. research and development is not a refundable tax credit. And so I know there has been some discussions about, is there the opportunity for another safe harbor to sort of bring in the R&D credit? Well, again, we're at the end of the year here. That's not in. So for those foreign parented groups operating in the U.S., it feels like the R&D credit is fair game for the IRs. But any reaction to that or thoughts about the potential of more safe harbors particularly for U.S. or other incentives?
Yeah, I mean, it's a great question. I mean, and just going back to what you were saying before about about the UTPR or the IR, I'm sorry, and countries which can't bring in transferable credits. I think that's a real point. It may well be, and I just don't know enough about administrative guidance in other countries. I mean, in the U.S., the IRS or the Treasury could issue a notice which says essentially we're going to deal with this in a certain way. It may be other countries can do that as well. I think from there the more interesting question is, if there are other countries which actually just don't agree with this, and they fail to, they can't be forced to put it into their legislation. So if they fail to do that, if they do that in a sense purposefully, that's another potential. I mean, you've talked about the folks who are too far along in their legislation. There may be others who use this to diverge slightly, and that's one of the issues you see with the QDMTT as well. They can adopt the QDMTT, but they can also miss out certain other parts of what's in that when they're looking at elements of the QDMTT and the safe harbor. On the R&D credit, at this conference in DC a couple of weeks ago, the US Treasury said this is an issue which needs to be dealt with. The OECD said slightly more, we're in Italy, sotto voce, that
well played.
Thank you. That they would, that they would be open to a safe harbor essentially. Now, exactly what the safe harbor looks like, I don't know. You could come up with many suggestions. I could come up with some suggestions. There is some question as to exactly how much weight safe harbors can bear, because if at a certain point they are not so much, here's how the rules work, but there are sort of elements of the rules which can be scratchy, and therefore, we'll present you with a simplified way of dealing with them. Well, that's a sort of straightforward safe harbor. If it's something which, as you've said before, essentially overturns the rules in a meaningful way, then can they do that? And obviously, it is very clear in the rules, and I mean, this is a problem with transferable credits as well. It says, they're qualified refundable tax credits, or they're not. And if they are, then, sort of they go on the income line. If they're not, they come out of the tax line. And that's the treatment, full stop. Yeah. That's it. It's there in black and white. So transferable credits is, already a stretch. Now, they've made an economic argument, which, sure, I accept. I told you before. And then, likewise, I think the R&D credit, is a good credit which should not be part of this. But it does go against the language of the model rules. And again, it presents a particular problem, I think, for the Europeans, for the EU people, I should say, because it does seem to be different. So you can come up with with a safe harbor, which says, for example, I mean, you can use a mixture of qualitative and quantitative things. You can say, if in general your global ETR is, X percent, where X is obviously a number larger than 15, but also, you're doing proper research and development, the R&D matches either the European rules or the US rules or somebody else's rules, and, you spend it in the country and blah, 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 blah. You can think of how you could do that. This is our safe harbor. Well, yeah, it is. Okay, that's fine. As a technical matter, it would work. But again, matching it up against the words of the model rules, it's a big change.
Yeah.
Now, it may be an appropriate change, but it's a big change nevertheless.
And again, I feel like, the U.S. policymakers have protected the base for the U.S. parented groups, but I just wonder if they have the appreciation for the non-U.S. parented groups, what is at risk in 2024 for those jurisdictions that own a U.S. subsidiary that have enacted the IIR.
Right.
And we'll see what U.S. policymakers' reaction to that could be as they start to understand that a little bit better.
Right, although I think the political reality is that first you deal with your U.S. constituents and then you deal with the rest.
I get it. And then I'm wondering, then they'll deal with the rest. We'll see what the reaction is. Maybe the last question on Pillar Two is really kind of just how business how is participating in this process, because one of the many roles that you've had in the past, you were the former head of BIEC or business at the OECD. You have given that up as you've taken on this global role at PwC. But what is your view on kind of businesses' involvement as part of this Pillar Two process? Are their needs being heard? And just kind of how is that going from your lens of kind of working with the OECD extensively in the past?
Yeah, so it's had its ups and downs, I think. I mean, 2021, I think, was not a great year. It was partly pandemic induced, but there was very little consultation at all. And, in the end, there was a bit of a blow up at the end of the year. As a result of which consultation then took off. Since then, the major, there have been one or two consultations, but still virtual, which is not so good, or not as good as in person. But the real point of contact has been the business advisory groups, and this is a relatively small group of businesses, both on Pillar One and on Pillar Two, who were picked for to represent both geographic diversity and sectoral diversity, and to talk more, in particular, to the Secretariat. Now, the Secretariat deserves credit on this. There has been quite a lot of interaction. Again, sometimes more than others when they're being pressed by the member governments, they have to do that. The trouble with the process is just there are, I call it the everything everywhere all at once problem. Which is they are trying to do so much. They're trying to do so much with so many countries at a in a time frame which is pressurized.
Right.
That it is hard to, I think, always talk to all of the stakeholders. And I when I was at BIEC, I made very clear, look, you've made the policy decisions, or you make the policy decisions. You have now made the policy decisions, but it makes sense to talk to business in order to get rules which work. And I mean, we've seen this, we've talked about this in relation to, in particular to sort of the modified deferred tax accounting that they've adopted. Businesses have experience of that. Governments actually don't have experience. Certainly tax authorities, treasuries, finance ministries don't have experience of that. So talking to businesses about that would be helpful. That some of those conversations have taken place. There have been conversations recently about the transitional CBCR safe harbor and the issue that the OECD have surfaced around anti-arbitrage. But at the same time, obviously the OECD also have to deal with, in the case of Pillar Two, Working Party 11, which is a lot of countries. Right. And it's been difficult to do everything. So business has had some say, or not some say, sorry, let me put that differently. Business has had the opportunity to have input into this. I think that it's gone okay, but in the end, we'll see next year when people have to start doing this stuff. And there is this question also about how long is this process going to going to carry on.
Right. Yeah, and I think the lesson that I have, and some of this is learned working with you, Will, is businesses should still stay involved.
Oh, absolutely.
And particularly, I think the U.S. multinationals are used to engaging in this.
Yep.
As I've traveled around the world, since I've taken this global role, I think maybe some of the non-U.S. taxpayers are maybe less inclined to go and have those discussions, and I would highly encourage them to. If nothing else, for the number of open issues that we discussed with all these questions about the UTPR, administrative guidance, how this is going to fit in. So I really think it's important for stakeholders, particularly the taxpayers themselves, because they hear the OECD, I'm sure, hears plenty from us advisors, but for taxpayers to actually engage in that process.
No, I think it's crucial. And again, it's taking this real world experience. And one of the problems with Pillar Two was, as you said, businesses in other countries, it's not like they're disinterested, but there is less of a tradition of engaging. And with Pillar Two, because for a very long time, guilty as grandfathered was the mantra, US businesses were all focused on Pillar One. And therefore, the business involvement in Pillar Two came relatively late in the game. When the model rules came out, which was kind of slightly after the event. Again, involvement since then has been good. But yes, have to stay involved, in part because what's going to happen next year is, sort of things start happening in the laboratory, if you will.
It's an important year.
Yeah, and people will, it's not that it's been theoretical up until now, but it hasn't, people haven't been required to actually, apply the law to make those forward-looking statements, all the rest of the stuff that you were talking about. And I think as people do that, issues will undoubtedly emerge. And business needs to have, to be ready to make those points as quickly as it can do.
Okay, well, we're going to leave it at that, Will. And the other thing that I did want to mention and plug is it was a great article that you have drafted. I don't want to shortchange that. It was in Bloomberg Tax, entitled Tax and ESG, Reporting is a Growing Undervalued Relationship. We'll leave that for another podcast, but I would encourage listeners to check that out, because there is a Pillar Two tie-in,
There is a Pillar Two tie-in.
which I don't think you expressly covered, but we'll leave that as a hook to keep listeners coming back. So, Will, always great talking to you. Interesting. Lots going on, and we'll continue to cover it here at the Cross Border Tax Talks podcast. So thanks for tuning in to this week's episode of Cross Border Tax Talks. Thank you, Will Morris, PwC's Global Tax Policy Leader. I'm Doug McHoney, PwC's International Tax Services Global Leader. Stay tuned for another exciting edition of the Cross Border Tax Talks podcast.
This podcast is brought to you by PwC, all rights reserved. PwC refers to the U.S. member firm or one of its subsidiaries or affiliates and may sometimes refer to the PwC network. Each member firm is a separate legal entity. Please see www.pwc.com/structure for further details. This podcast is for general information purposes only and should not be used as a substitute for consultation with professional advisors.